Hey class, welcome to week 11. Today we are going to continue our look at judicial review. So now that we have talked about standing, let's move on to some other crucial considerations such as the timing of judicial review. The Administrative Procedure Act provides for judicial review of final agency actions. And getting to that final agency action, it requires that the plaintiff in the case, the person bringing the case, has exhausted her administrative remedies and that her case is ripe for review. There is another doctrine that can delay judicial review of agency action, and that is the doctrine of primary jurisdiction. Now, this applies to closely regulated businesses, not to everyone generally. Primary jurisdiction is the requirement that disputes between two private parties get raised before the agency that has regulatory authority over the issues in dispute. So most often, you would see the doctrine applied to businesses that are required to, for instance, have a certain license issued by the federal government. If two, radio station licensees have a dispute with each other, they got to take that up at the FCC first. Another example, trying to make it a little bit simpler, would be a suit between a person, let's say John, and a regulated business, let's say ABC Student Loans Incorporated. That business is regulated by the Consumer Financial Protection Bureau. The CFPB knows its regulations and will have a better understanding of the facts than a court. So the court will first send the dispute to the Bureau to get a ruling. This doctrine of primary jurisdiction, it exists for reasons of judicial economy. It just makes more sense to let an agency engage in fact-finding because the agency's got more expertise and the agency can compile a complete record that the court can then review. Now, courts realize that agencies might not be able to resolve the case, and that just doesn't matter. The court will still send that case to the agency to engage in fact-finding. Another delay in getting into court is the requirement that you exhaust your administrative remedies. This means that the plaintiff has to pursue all administrative remedies, that is, agency-level remedies, and allow the agency to come to a conclusion before the plaintiff files suit in court. This doctrine is also based on the idea of judicial economy. It is cheaper and easier for agencies to engage in fact-finding in their area of expertise. It also allows agencies to correct any mistakes that they have made along the way, so they can self-correct. And that might actually mean there's no need to go to court at all. But if the case does go to court, the doctrine of exhaustion of administrative remedies means that the court is going to have an accurate and complete record to review. To determine what administrative remedies have to be exhausted, we look to statutes, regulations, industry practice, and even contracts. So for example, a government contract might require the contractor, if they've got a dispute with the agency, to first file a certified claim with the federal agency contracting officer. And then if that's no good, appeal up to a board of appeals, a board of contract appeals, and possibly even go to the GAO, which handles some contract disputes, before filing suit in a regular Article 3 court. The exhaustion of available remedies, it also requires compliance with procedures. The plaintiff has to submit the claims in the proper format to the proper agency officials in the proper order by the agency deadline. Here is an example of the process to exhaust administrative remedies. Let's say John files a claim to receive Social Security benefits. If the agency denies John's claim, and that would be an informal adjudication, it would just be a piece of paper that he got in the mail, then John has to follow the Social Security Administration's policy and ask the claims office to reconsider. If the claims office denies the request for reconsideration, then John has to appeal to an administrative law judge. And if the ALJ denies John's request, then John has to appeal to the agency itself through its appeals board. And only after the appeals board has denied John's request can John file suit in court. He also has to file suit in the correct court. So here, a U.S. District Court, possibly located in Washington, D.C. I would have to pull some statutes. There are, of course, exceptions to the doctrine of exhaustion of administrative remedies. A court will take up a case where the plaintiff has not yet exhausted all of those remedies if the agency has unreasonably delayed in holding a hearing or unreasonably delayed in issuing a decision. Because in that case, the plaintiff has done everything they can do, and now it's up to the agency, and if the agency is dragging its feet, then that is an exception to the doctrine. Additionally, if there is a civil rights claim, and we will cover a class of civil rights claims called Section 1983 claims a bit later in the semester, but if there's a civil rights or some other type of constitutional claim, that is an exception to the exhaustion of administrative remedies. A court will take the case, and that's simply because agencies don't have any authority to declare a statute unconstitutional, so there's just no point in exhausting those remedies. You might as well just go straight to court. However, you can only be heard in court if your case is ripe. Courts only have jurisdiction over actual cases or controversies, so not potential disputes, and that is written into Article 3 of the Constitution. So typically, in administrative law, if a regulation is pending, but it hasn't yet been issued in final form, or it's been issued, but there's a period before enforcement begins, then technically there is no case or controversy and the issue is not ripe. Now, at common law, this left a party with only two choices when it came to what to do with a questionable regulation. The party could comply with the regulation, often at great expense, and then seek judicial review, or the party could fail to comply with the regulation, suffer the penalty for noncompliance, often at great expense, and then seek review. In order to provide a better option for the plaintiff in that type of common law case, we now have the possibility of pre-enforcement review. So pre-enforcement review in a court is available where a pending regulation could cause substantial harm. So the primary case on point for this is Abbott Laboratories v. Gardner. No relation, that's a D, I'm a T. But it's a Supreme Court case, Abbott Labs v. Gardner. And in that case, the FDA had a regulation that required a prescription drug's name to also include the generic name on all labels and all printed materials. Now, FDA labeling requirements are a very big deal to pharmaceutical companies and medical device manufacturers. It costs a shocking amount of money to label these packages. So in this case, Abbott Labs argued that pre-enforcement review was necessary because it was either going to have to recall all of its already labeled products, which were perfectly safe and fine. This is merely a labeling issue. So they would either have to recall all of that from the shelves of pharmacies and hospitals, very expensive process, or knowingly let those incorrectly labeled products remain out there and face a hefty fine from the FDA. The FDA in this case argued that the case was not ripe because the FDA had not yet enforced the regulation against Abbott. But the court disagreed. The Supreme Court said, prosecution is very likely here, and there's a substantial hardship to the plaintiff, to Abbott Labs, if the courts deny a pre-enforcement challenge to the regulation. It was a no-win situation for Abbott Labs. They were damned if they do, damned if they don't. And thus, there was a controversy, and the case was ripe enough for a court to review it. So courts look to three different issues to determine whether a case is ripe. First, they ask if the issues are fit for review. Legal issues are more suitable for immediate judicial review than are factual issues, and that's because courts interpret the law and agencies find the facts. Second, courts ask whether the plaintiff has exhausted administrative remedies. The more remedies exhausted, the greater likelihood that a court will determine that the case is ripe. So those are really the two tests of ripeness. In addition, courts do look to see whether the plaintiff would suffer a significant harm if pre-enforcement review was not available. And the greater the harm, the more likely that a court would allow that pre-enforcement review. Before we move on to the second part of the lecture on scope and standards of review, let's just run quickly through the requirements for judicial review. First, a court has to have the authority to hear the case. Either the statute or the common law is going to provide such authority, assuming Congress has not restricted judicial review by statute. Second, because Congress can limit judicial review, in particular by imposing a statute of limitations, the plaintiff has to file suit within that window, or else the court is going to lose the authority to hear the case. You are probably most familiar with statute of limitations in the criminal law capacity. For example, you may know that there are no statutes of limitations on the crime of murder. Those charges can always be brought. The courts never lose their window of opportunity to hear a murder case. Third on our checklist, the court must have appropriate jurisdiction over both the parties and the subject matter of the case. Fourth, venue's got to be appropriate. That means it's got to be the location where the parties live or have their headquarters, or the location where events giving rise to the case took place. Parties can waive this though, remember, so parties can waive venue. Fifth, the plaintiff must have standing to sue. The plaintiff must have suffered an injury, attributable to the defendant, and redressable by the court. And finally, sixth, the case must be ripe. Okay, so a court decides the plaintiff has a right to have her case heard, and the court has a right to hear the case. Now what? Now the court has to determine the scope of its review and the standard of review that it is going to apply to the case. The Administrative Procedure Act specifically provides for judicial review of agency actions, and it sets forth the scope of review. So you can see it's pretty broad. It allows courts to oversee agency actions and both compel action if the agency has unreasonably delayed or unlawfully failed to act, but it can also enjoin or prohibit agency action if the agency is acting outside the scope of its authority, acting outside of that sandbox created by Congress. You see here, Section 706, it specifically states that courts can decide all relevant questions of law, as well as determining the meaning or applicability of an agency's action. So courts can overrule agency action that is arbitrary and capricious, or contrary to a constitutional right, or in excess of the agency's statutory authority, or otherwise clearly erroneous and unwarranted. So the scope of a court's review refers to the issues the court will examine. How far is the court going to go in examining the agency's findings of fact, conclusions of law, and legal analysis? And the scope breaks down into, is the court looking at questions of fact, questions of law, or questions of both fact and law? Sometimes we just call that mixed questions of fact and law. A question of fact, that is answered by referring to the facts of the specific case at hand. You're looking at the evidence presented in this case. And a question of fact applies only to the case at hand. So an example of a question of fact is, did ABC Corporation use chemical X in its Indiana factory? That fact is relevant solely to ABC Corporation and its Indiana factory. A question of law is answered by applying relevant legal principles to the case at hand. And a question of law applies more broadly. It applies to all similarly situated parties. So an example of a question of law is, does the Clean Air Act prohibit the use of chemical X in factories? If the answer is yes, then that applies to all factories, not just ABC Corp's Indiana factory. Now, in criminal and civil law, the judge usually determines questions of law, and the jury determines questions of fact, unless the defendant has waived trial by jury and is just going for a bench trial. In administrative law, much like in a bench trial, the court determines both questions of law and also questions of fact. Now, scope, it matters because it can determine the standard of review that a court is going to use. There are many different standards of review that apply in different cases. You actually already know a bunch of them. Like Chevron doctrine, it's got deference, it has the application of the arbitrary and capricious standard, as well as the substantial evidence standard. And we're going to run through some of these more common standards of review. So that includes de novo review, substantial evidence, arbitrary and capricious review, and then the various standards of deference to agencies, Chevron, Auer, and Skidmore. Now keep in mind that we are not talking here about constitutional questions. Courts apply different standards to constitutional questions, specifically rational basis review, intermediate scrutiny, or strict scrutiny. And we went through those back when we had a discussion of constitutional law and issues of fairness for agencies. So de novo review is a fresh start. The court doesn't give any deference to the agency's finding of facts or conclusions of law or its analysis. De novo review is primarily used to review questions of law or mixed questions of fact or law, but it is also the standard that courts use when Congress says to use it. Congress can specify that in a statute. So in a de novo review, the court may order an entirely new hearing. The court can throw out the agency record and go through the whole process of collecting evidence and testimony from scratch. So they just start all over. That is known as pure de novo review. Alternatively, the court can review the record of an agency's hearing and then make its decision based on evidence from the record. So that is record de novo review. The court doesn't have to go and get witnesses and evidence again. The agency record is sufficient. So while de novo is a totally fresh start with no deference to the agency, substantial evidence review gives some deference to the agency's findings. This standard of review, though, it is used to review formal rulemaking and formal adjudications. And as you know, most agency action is informal. So this will only apply to formal action. And under the substantial evidence standard of review, courts examine the agency's records of facts and conclusions, and a court will affirm an agency's decision so long as it is supported by sufficient evidence. So what counts as sufficient evidence? Courts apply the reasonably prudent person doctrine. So evidence for an agency's action exists where a reasonably prudent person, under similar circumstances, could reach the same decision that the agency reached. Notice I said could. There's a lot of wiggle room here. So in this type of review, the court is limited to the administrative record. However, if that record is spotty or the court thinks the agency missed something in the fact finding, it can actually remand the case back to the agency. All right, and finally we have the arbitrary and capricious standard of review. This is the standard that applies to the review of all discretionary or informal agency actions. And so it is our default standard because most agency actions are informal. So when reviewing an agency's informal actions or decisions, and that includes informal notice and comment rulemaking and informal adjudications, the court gives a great deal of deference to the agency. The court is going to assume that the agency's decision is valid as long as it is rational. There's just got to be some type of rational basis for it. So since that has a lot of wiggle room, rational can mean different things to different people, when is an agency's decision going to be arbitrary and capricious? So there are a couple of really clear times. For instance, if an agency relies on factors that Congress did not intend it to rely on, if Congress set forth factors in a statute and the agency doesn't use those and uses something else, that is arbitrary and capricious. When the agency entirely fails to consider some important aspect of the problem, if they've got their heads in the sand because they don't want to see it, that can be arbitrary and capricious action. Also, when the agency's decision is just not supported by the evidence or runs counter to the evidence, or where that decision is so implausible that it can't be explained as a difference of opinion, or difference of agency expertise. Okay, so those three standards, de novo, substantial evidence, and arbitrary and capricious, they are often used to review agency action, sometimes in agency inaction. And agency action includes findings of fact and conclusions of law that an ALJ provides, in writing after a formal adjudication. But for questions about statutory or regulatory interpretation, we have to think back to our lecture on agency discretion, because we are once again in Chevron doctrine territory. The Chevron doctrine, it itself helps courts determine whether they should apply de novo substantial evidence or arbitrary and capricious review. So under Chevron, as you probably remember, because it's the most important case in administrative law, if there's a statute specifically on point, courts use the de novo standard of review. They look at the agency's action from fresh eyes. If there is no specific statute on point, and usually there is not, then the courts ask whether Congress explicitly delegated to the agency the authority to promulgate regulations. Sometimes Congress does say, Secretary of whatever, you must promulgate regulations. So if the answer is yes, courts apply the arbitrary and capricious standard for informal action. They apply the substantial evidence standard for formal action. And if Congress did not explicitly delegate authority to create regulations, then courts simply look to see if the agency acted reasonably. Likewise, the Auer deference, that gives us the clearly erroneous standard. A court will not overturn an agency unless the agency is obviously wrong. And then there's Skidmore deference, which is mere respect for an agency's interpretation of its own authority. All right, quick recap of standards of review. Scope of review helps the court determine which standard to apply. Questions of facts, agency decisions, and agency conclusions are reviewed de novo or with the substantial evidence standard, or most likely the arbitrary and capricious standard. Pure questions of law, statutory and regulatory interpretation, for instance, are subject to the Chevron, Auer, or Skidmore doctrines and their accompanying standards of review. Now, there are some common law doctrines that limit judicial review. These doctrines are primarily concerned with being fair to the parties. And because these doctrines come to us from ye olde common law, they have ye olde names. So first we've got the doctrine of res judicata, also known as claim preclusion. And this prohibits a party from relitigating a final judgment where the parties and the claims are identical. It's very similar to double jeopardy. You only get one bite at the apple, and if that bite fails, you don't get to try again and again. Similarly, the doctrine of collateral estoppel, also known as issue preclusion, prohibits a party from relitigating an issue that was decided in a prior case where the parties and the issues were identical. Now, estoppel is probably not a word you encounter much if you're not an attorney. It is just a fancy way of saying that the court will stop or prevent a party from making certain assertions. So res judicata, that applies to the whole claim. Collateral estoppel applies to particular issues within the claim. And both doctrines prevent the party from taking another bite at that apple. Other common law doctrines prevent a party from unfairly raising a claim in the first place. So we've got the doctrine of equitable estoppel, also known as promissory estoppel, and it deals with promises. If a party makes a promise, that promise becomes binding if the party making the promise, the promisor, intends the promise to induce reliance from the other party, or if a reasonable person would expect that the promise would induce the other party to rely on what is being promised. It also requires that that other party, the recipient of the promise, actually does rely on the promise. And then it requires the court to find that if a promise is not enforced, the party that relied on it will be harmed. So this is really just a way to make sure that there is fairness amongst the parties. The laches doctrine. Laches is derived from a French word for remiss or slackness, and my high school French teacher would be just horrified to hear me call it laches, but that's what we call it. It means that if a party unreasonably delays in raising a claim, the court is not going to review the claim. It's kind of like the common law version of a statute of limitations. So parties have to raise issues and claims in a timely manner, or they can't raise them at all. And in large part, this is to be fair. If you get into a fender bender and you don't hear from the other driver fairly soon, then you're not going to expect to be hit with a lawsuit 5 years later. That would just be unfair. And in addition to being fair to the parties, the laches doctrine ensures that claims are brought within a reasonable period, because that's the time where you can get witnesses and evidence while everything is still fresh. All right, let's take a look at a case study to illustrate the various concepts underlying the doctrine of judicial review, because this is like a lot of legal mumbo jumbo that might not be as easy to consider and apply in real life. So in this case, Lex Luthor is going to take on the Environmental Protection Agency. So Lex wants to store his kryptonite for business purposes, and he comes to you for help. You do your research. You know that the Resource Conservation and Recovery Act applies to the storage of kryptonite. You take a look at the act. You determine it contains no magic words that require formal agency action. It reveals no congressional intent to prohibit judicial review. It does have a statute of limitations 2 years after the incident giving rise to the lawsuit, and it requires that all suits be filed in the U.S. District Court for the District of Columbia. That act has no express delegation of unlimited discretion to the EPA. Our textbook calls that committed to agency discretion by law. And the act does not specify a standard of review. So you look at the EPA, and you determine that it has procedures in place that allow for appeals to ALJs if the EPA permit office denies a permit. So the agency is not required to engage in formal adjudications, but it has adopted something similar. So, according to the Act, and with all appropriate informal notice and comment, the EPA issued regulations for the treatment, storage, and disposal of kryptonite. That's informal rulemaking. And those regulations require that Lex obtain a permit to store his kryptonite. So because you are the expert at this, you prepare all the proper documentation, you've got all the necessary information required by the Act, and Lex applies for his permit. And the EPA permit office denied Lex's permit application. And it might have been coincidence, but the denial came on an envelope with Superman stamps on it. So Lex requests reconsideration of his permit application, which then the EPA permit office declines to provide. Now, using the EPA's procedures, Lex appeals to the EPA Office of Administrative Law Judges, and the ALJ upholds the denial of the permit. You think those findings of fact are wrong, and her conclusions of law seemed iffy. So then Lex appeals to the EPA administrator, who denies the permit while intentionally showing off his Superman cufflinks. So Lex now thinks that the animosity between him and Superman is the reason that the EPA is refusing to properly review his permit application. So Lex comes back to you and asks, can I appeal this decision to a court of law? So the questions are, is Lex entitled to judicial review of the EPA's permit denial? And what standard of review should the court use? So first, we have to look at the source of authority for judicial review. Now, in your day-to-day life, you can assume that the vast majority of agency actions are reviewable, but for our purposes, we look and see, can courts review the EPA's action under the Resource Conservation and Recovery Act? Yes, they can. We know this because of the text of the act, including what is not written. So we know that Congress did not explicitly prohibit judicial review in the statute. There's nothing in there that attempts to strip the courts of jurisdiction. We know that the EPA's action is not committed to agency discretion by law because that would have required an express delegation by Congress. Congress did set a 2-year statute of limitations, and Congress does require that suits be filed in the U.S. District Court for the District of Columbia. So while Congress has slightly narrowed the window of judicial review, the judicial branch does have the authority to hear the case, both based on the statute and common law. And specifically, the U.S. District Court for the District of Columbia has jurisdiction over the case. So now we know that the court has authority, and we have to ask whether Lex has standing to file suit. And the answer is yes, he has standing to sue in the U.S. District Court for the District of Columbia. Lex meets all 3 prongs of our modern test for standing. He was injured. The denial of the permit, it affects his commercial interests, causing him to lose money. So it's a financial injury. It meets the injury in fact test. Lex's injury is the result of EPA's action. In this case, it's denial of his kryptonite storage permit. And his injury is redressable. If Lex prevails at trial, the court can require the EPA to issue the permit and possibly provide additional remedies. So we know that Lex has standing, which is the authority to be heard in court. Next we ask, is the case ripe enough that the court has the right to hear it? And yes, Lex's case is ripe for review. He has exhausted all of his administrative remedies. He has already made his case to the EPA administrator. There is literally no one higher up in the agency. So yes, his case is ripe. So Lex is indeed entitled to judicial review. So now we ask, what standard should the federal district court apply in reviewing the EPA's record for Lex's case? And it should use the arbitrary and capricious standard. And that is the default standard of review because it's the standard for informal agency action, and most agency action is informal. So in Lex's case, because the act itself doesn't specify a standard of review, and because the EPA's actions were informal, because there were no magic words to require formal adjudication, the court is going to give a lot of deference to the EPA. It is only going to set aside the EPA's actions if the EPA acted arbitrarily or capriciously. Now, normally, that's a very, very big hurdle. Courts can usually find some reason for an agency's action. But here, it really does seem like EPA officials were biased against Lex Luthor because of his ongoing beef with Superman. And so I think that this might be a rare case where Lex has a good chance of winning at trial, in which case the court would likely order the EPA to issue the permit and Lex would be back in business. All right, this was a short lecture. I am hoping that this is going to just give you some time to work on M2, which is due at the end of week 12. Also work on your policy analysis memo. I apologize for not being on the news item board as much in this past week or so. Work, as I'm sure all of you are also experiencing, has been fairly crazy. But I will be on the discussion boards, looking at the news items, looking at the M2 discussion board. And so I want you to have a good week. And maybe I will see you on one of those discussion boards.